Hey everyone, in today's video we're going to have a look at intellectual property. So as a theory, this is probably most likely to come up in paper 2 because it's to do with the theory behind design and how designers can protect their work. So there is actually quite a few things that you need to be aware of. So the most common one people know obviously things like copyright. There are also things like copyright, design rights, patents, registered designs, trademarks, and open designs. If you are studying A-level business or BTEC business, some of these terms you may have come across before. There's a couple I expect you probably like copyright, you've probably heard before anyway, but you might not know exactly what it covers. But basically, what I'll do is I'll go through what each one of them is, what it covers, and then the limitations for what it can't do as well. So the first one, copyright. So this is basically legal right is given to the person who has created a thing that's been physically expressed. So that might be things like a piece of art, a digital database, dramatic work, a piece of like a film, literature, music, photographs, software, sound recordings, radio, or like TV broadcasts. So it's not something that you can physically like hold. I mean, actually like a DVD or something, but in terms of like it's something that's been physically expressed, as in it's not like a tangible physical product, but it is a thing. So it's like a piece of music, or it is a film, or that sort of thing. So in the UK, now it's important to note that it's different in depending on which country you are releasing things in or which country it's been created in. But in the UK, there is no formal registration process. As soon as something has been written down or recorded or created, copyright automatically exists. So copyright lasts for the life of the creator, so whoever has created it, plus 70 years after their death. So if you think about it in terms of like music, things like Michael Jackson and people like that, so they died, I should have looked that up before I brought that up. Michael Jackson died X amount of years ago, definitely not 70 years ago, at least. So obviously, while he was alive, his work was protected by copyright. Then now that he's dead, it's still under copyright, and so it will all still go to his family, his children, those sorts of things. So under current UK copyright legislation, there's something called the Copyright Design and Patents Act of 1988. So that's the bit of legislation that actually physically protects it. And the copyright logo, which is something I'm sure everyone has seen before, is a circle with a C in the middle of it. And typically what they will have, which you don't see here, is the date of it was created in, to let you show and know when it was claimed, basically. So unregistered design rights. So design rights, now we're going to go through unregistered design rights and design rights because they're two slightly different things. So design rights basically looking to protect the look and appearance of a product in a particular, like things like its shapes, its colour, its textures, its materials. Obviously what you can't do is just say, all right, I'm copyrighting the colour orange, because that's ridiculous. But if you take someone like McDonald's with that yellow M, that particular shade of yellow will be protected. Same with things like Cadbury's purple. Okay, those sorts of things. So you can't just say, all right, I'm claiming that entire colour, and then it uses that colour, I'm going to sue you, because that's not how it works. But what you can do is particular colours and shapes of those sorts of things. So things like that, so the shape and configuration of the product, are automatically protected by unregistered design rights. You can also get stronger protection from the Intellectual Property Office to get registered design rights. So you automatically have unregistered design rights, but then if you want to get more protection on top of that, you can then go and get registered design rights as well. The overall impression of the product, so the overall thing of it, must be novel and original, and you can't do anything like offensive or incorporate an emblem or a flag. So things like Olympic rings, and this one's going to be a bit controversial, but things like the swastika. If you are not aware, originally it actually was called a manji, which is part of a Buddhist religion, which means peace. Obviously, someone came along and then turned it to its side and made it an incredibly like horrible hate symbol. But there's also, and that's again the reason why you can't see it on things now. But you can't use those sorts, even if it wasn't a symbol of absolute hatred and those sorts of things, you wouldn't be allowed to use that as part of a design anyway, because it would not be allowed to be incorporated because it is a protected emblem. So next you've got design rights. So this stops people from having identical or near identical designs. So this is where you'll have some products that are going to be very, very similar, okay? Because there's certain products that no matter how careful competitors are, you're going to have similar kinds of work. So basically, designs are owned by the designer or the person who's commissioned that work. Now, it's slightly different from copyright because copyright is the person that creates it has it. Whereas with design rights, you can either the designer who's done it owns it, or that they can give the rights to the person who has commissioned it. So, say if you are an independent designer and someone commissions work from you and you design something for them, you then have to physically hand over the design rights to them, and that has to be like paperwork to go with that, which we'll go into. For unregistered design rights, as we said before, protection is automatic, but you do need to be able to prove when it was created. You can't just say, "Oh no, I did it years and years ago." The best way to do that is file copies of designs, including like detailed descriptions, photos, with like typically it'll normally be like a solicitor, someone that works in the law industry, or it might even be with your bank. Or what you can do, which if you are just starting out, which what a lot of people do at university when they're starting to get into the industry a little bit, is you have your work. What you can do is you can send it to yourself via email, and then you can have dates, times, those things on those. So then you've got a paper trail of everything you've got, and all that is doing is just basically setting out so you can say, look, I know I created this design. Here are my original CAD drawings. Here are my original sketches, and this is the email. Sent it to me on this date. It proves that this is when I had it. And it creates this sort of backlog of paperwork that says, look, I know I had it on this time. Protection lasts for about 10 years from when the product was first sold. And then what you can do is you can get 15 years from when it was first created, and it depends on which one is earlier. So whichever one comes up first, either the 10 years from when it was first sold or the 15 years from when it was created. Once it's done, you cannot renew it. Design right, so just worth pointing out as well, it doesn't protect the functionality of how something actually physically works. That falls under something called patents, which we'll go through in the next couple of slides. Okay, so registered designs, part 2. So design rights, we've got registered designs. So this, again, is covered by the Intellectual Property Office. And this can protect a product, either a whole product or a particular part of a product. And again, this sort of goes over the whole idea of products that are going to be slightly similar, but different as well. Because if you look at like smartphones, I mean, realistically, every smartphone looks the same. It's a black rectangle with touchscreen technology. Same with like chocolate bars. It's a rectangle of chocolate. I mean, how different can you really be? Okay, but you need to have certain things that stand out to make it look a little bit more different. So registered designs is protected in the UK and the EU. That's exclusive designs for a maximum of 25 years. You have to renew it every 5 years. There's a couple of rules you have to follow. One, it must be new, so it can't have been disclosed anywhere in the world before you file it, so you can't have like had it discussed on TV. So things like the Dragon's Den and things like that will have to have all the paperwork in place first before they go and publish it on TV, otherwise they wouldn't be allowed to do it. It must also be of individual character, so you can know that it is not copied from anywhere. So I've got a couple of examples. You see, obviously, you got like Cocoa Pops, and you've got to see if you go to like Lidl and Aldi and places like that, or you have like the quote unquote like knockoff versions of things. They change it just enough that it's not infringing on the registered designs. There was something that happened last year, I think it was. So 2020. Wait, what year are we in now? 2021. Okay. In 2020, there was obviously Colin Caterpillar cake. Marks and Spencer's brought out their own version of Colin the Caterpillar. Lidl brought out their own version of Colin Caterpillar that was apparently too similar. So then they were in a whole legal battle about that as well. So there are a lot of toing and froing between companies. So it's quite obvious sometimes when they're copying, but if you change it just enough, there's not really much you can do about it. Trademarks. So trademarks can consist of things like drawings, symbols, 3D signs, shapes, packaging, and that type of thing. You can also, in some countries, non-traditional marks can be registered for distinguishing features such as things like motions, colours, holograms, non-visual signs. Basically, this will be your whole brand. So it will be like your company's logo, your slogan, so McDonald's M, and the I'm loving it, or Nike, on the tick and just do it. So basically, everything that goes around that brand will be trademarked. So if you look at all logos, down at the bottom will be a very, very small TM in the bottom right corner of it. They need to be registered for each country you're planning to sell it in. Okay, so trademarks are only viable in the countries that they've been registered to already, which is why you get so many knockoffs when you go on holiday and people trying to say like Gucci glasses and Parmani watches and those sorts of things. okay, is you need to make sure things are trademarked in select countries, or you run the risk of people having knockoffs of your things. So you can apply to have a registered trademark. So this is just literally on the UK government website. Type it in, it'll go through the whole thing. There's a load, it's a very, very lengthy process. You can go through, I won't show you the whole website, but you can just have a look down. It'll give you loads of questions to go through to see if you're eligible, basically, to do it. Then you've got open source. So open source is quite a generic term depending on what you're doing. So you may have things like open source software. So I'm recording this on OBS, which is open source recording software. Anyone that streams will use the same sort of thing, like on Twitch or YouTube or wherever you stream, you use the same sort of software for that. Same with things like Thingiverse, and I was into that 3D printing. That's all open source. So the idea is, what you can't do is take it, claim it as your own, and make money. The idea is it's there that can be modified. I wish to modify it. The idea should be that you have to make it available to everyone else as well. So the idea, it keeps getting developed and improved on by each person. They keep making their developments available to other people as well. Then you've got patents. So I said before that the functionality of products can't be covered by design rights. That's just to do with like the appearances, the textures, the shades, those sorts of things. The functionality of things need to be covered by patents. So patents give you exclusive rights for things like inventions, a product, or a process. So there are a few rules. It needs to provide a brand new way of doing something, and it needs to be a technical solution. So you need to know how something could physically work. So what I can't do tomorrow is go in and get a trademark for hover cars, or flying cars, or hover boots, and go, okay, how does it work? Don't know. What, 50 years, that might happen. So if someone thinks of it, I own it. That doesn't work. You need to be able to explain properly exactly how it all actually functions, how it all work, the ins and outs of every little bit of detail. Then you can get a patent on it. So a patent is granted for typically about 20 years. You can get slightly longer ones, but the typical one is 20 years. That means it protects it from being commercially made, distributed, or sold without the patent owner's consent. You can sell your patent or rent your patent out. So it might be that someone comes to you and goes, look, I would like to use your product or the function of how something works for 5 years. And then you can agree to, okay, I will let you borrow it. I will rent it out to you for £100,000 or whatever it is. I'm just throwing random numbers out, by the way. That's not specific to anything. But as the patent owner, you are allowed to do that. What it does mean as well is that what you can do is, if someone uses your patent without contacting you, without making any financial compensation, then you have got grounds to start legal action. It is the most difficult type of protection to obtain. It's advised, if you're doing it, to seek advice from a patent lawyer or a patent attorney. According to the UK Intellectual Property Office, only 1 in 20 applicants get awarded a patent without professional help. The process can take up to 5 years and typically costs around £4,000. Once it's been granted, you need to renew it each year, otherwise it will become void. So patents only protect an invention in the country, again, where it's registered, same as trademarks, so you need to register it in each country. So a single application under the Patent Cooperation Treaty covers over 140 countries. An application with the European Patent Office offers protection in more than 30 countries in Europe, so you can make sure, basically, go to the right patent office and you can get it covered in Europe or Africa or wherever it may be. So digital intellectual property. So especially this day and age, with everything being digital anyway. So a digital asset is something that can be stored and transmitted in an electrical form. So that'd be things like software, photos and images, music, film and video, graphics, websites, computer animations, and databases. There is a bit of overlap with what we've discussed before, because you're probably seeing like things like databases and websites before. But digital intellectual property, because the whole world is going digital now, it's emerging a lot more. So the creator or the first owner of the piece of work will automatically have copyright protection on it with the little C. And then they will often have like all rights reserved. So they'll have that on there to say, look, this is mine. You can also get patents that apply to software if it's got a very, very unique, specific way of doing something. Some digital assets can be digitally protected, and that's because you can encode or encrypt them or watermark them. And not that you should, but if you ever try to illegally watch a film, for example, you may have found like on the film, it may say that it's for, there's like watermarks across it to try and like stop people from taking it and putting it on bootleg DVDs or anything like that. So that doesn't prevent unauthorized use of the assets for photographs and films and things, but it's meant to dissuade you from doing it. So basically, having the big watermarks across it will stop it. It's the same if you ever tried to get like a photograph before, you think, oh, it's free, keep going. Then you try and download it, and it's just got writing right across the middle of it. Okay, same with like your school photographs. So when you get your school photographs, if you remember doing that, when you had to do your hair, make sure you look really nice and smell, so you to get a nice picture of your school uniform. They'd be given like a sample one that had writing across it, so that they could see if they wanted it, and they could buy the real one with the watermark removed. So NDAs, non-disclosure agreements. The most common way people know about this really is through things like footballers or politicians or people doing something they shouldn't do and then making people sign non-disclosure agreements. That's the most common reason why these tend to be in the news. But in the world of like design and like that type of thing, typically what it's done is two companies that are going to start to do business, they'll sign confidentiality agreements, so basically a non-disclosure agreement, so that companies can't talk to each other to like figure out information and then go off and sell that information to someone else. Okay, it means if you do, then you are going to be in a lot of trouble. You're going to have a lawsuit on your hands. But typically, it just means like if we're going to do business, we'll both agree on NDA, we'll sign it, and then we know that our intellectual property is safe. But I said the most common thing you see it for now is because footballers done something stupid, or politicians done something stupid, or someone's done something they shouldn't have done. So how to avoid intellectual property infringement. So basically, as I've gone through a lot, as I said, that you can get like legal proceedings. So most commonly, you'll get things like civil law action or criminal proceedings. If someone is taking your work, you have got rights to sort of prosecute them, or if you've taken someone's work, you can expect to have fines or maybe even worse. There's a few things you need to do to try and like avoid it, because if you're going to go into architecture, engineering, design, some of these things may come up. So when hiring outside sources to create something for your business, so say for example, a freelance designer's come in, work doesn't automatically transfer to the company. When it's written into the contract, you need to make sure it's explicitly stated, right, I am going to design this website for you, I'm going to design this product for you, or whatever it is. And once done, it then goes over to the company. There was, slightly unrelated, but I'm sure we've all seen the Hangover movies, and that character that has the Mike Tyson face tattoo. Tattoos are quite an interesting one, because there's now been a lot of people that are saying that the artists have intellectual property rights or design rights over the tattoo because it's their work. And then if they become famous, they become models, they become movie stars, then they should be compensated for that. And there was the person who designed that Mike Tyson tattoo was saying he was owed compensation, and I can't remember how that came that ended, but I'm pretty sure he ended up getting quite a good chunk of money for it. Typically, what you need to do is, if they're a bigger company, they'll have to do an audit to make sure that they own all the intellectual property that they're working with, and if they haven't, start that process to get all the paperwork in place. So, enforcement of intellectual properties. So, basically, the things you need to make sure you're aware of: copyrights, patents, trademarks, design rights. Those are the ones that, as soon as you break into those, obviously, that's where the legal proceedings come from. The most common kind of things that happen if people break any of those rights are mediation, litigation, and settlement out of court. If possible, what will happen is you want to avoid going to court because that is expensive. Mediation is often the cheaper option because it means that businesses can carry on doing what they're doing and say, okay, look, we'll sit down, you're using this, you shouldn't have been using that. How much money have you made from it? Okay, you made this much money. Okay, we want 40% of it, 20% of it, whatever it is. And then what I would like to do is you keep paying me and you can still keep using it. So basically, you come to a financial agreement that everyone can still carry on with what they're doing and you still getting paid for what you've created. If you do go to court, you then need to have specialist judges that deal only with intellectual property cases, and that can be a very, very expensive process. Okay, and last little bit, just to show you other things that can happen. As we said before, is most things that happen, most different cases are involved in civil law, or they are done through mediation and meetings and things like that. But typically what will happen is most people that have had their intellectual property infringed upon won't really be aware of it until it's already been done, which sounds quite dumb. But if you think about like all the knockoff like handbags and clothing and jewelry that you find, is that they'll be going for a long time before they're eventually caught. You can make complaints, so to the police, trading standards, or action fraud, but doing a complaint cannot make the enforcement agency take action. So they might decide that it's just simply not worth their hassle. So to give you an example is, I have a family member that wrote a couple of books. He then found out his book was published in things like Mandarin, Spanish, those sorts of things. So he had like a couple of different countries. He found out one of his books was being published in Hungary and Bulgaria, and translated without his permission. He contacted a solicitor and basically was told it is not worth your time and money. It will cost you so much money to actually take them to court. You're going to lose money, and basically told them to just back off and just, it's fine, don't worry about it. So yeah, those are the kind of things that will come up. Okay, so a couple of questions to have a look through. So if you're looking page 150 to 155 in your textbook, answer those. Then if you've got any questions, let me know and I'll get back to you.